Hello world, welcome to Rex Arthur TV. This is the Rex Arthur Show, where we discuss LGBTQ issues with an LGBTQ approach and an LGBTQ perspective in an LGBTQ plus planet, and also a humanistic approach. And we are on Article 7 of the UDHR. We are doing a marathon going through article by article. So Article 7 is lap 7, and we are going to look at equality before the law. This is also similar to Article 6, the recognition as a person before the law. Now for Article 6 is different because it is right. You have a right to recognition as a person. But Article 7 is equality before the law. So this one, and is a very favorite one of Obama. Obama loves this, or most Democrats. The right to equality before the law as part of the right to a fair trial is enshrined in the Article 7 of the UDHR, and it's also part of the International Covenants of Civil and Political Rights. And here, everybody shall be equal before the courts and tribunals, and they will therefore be entitled to fair and public hearing by a competent, independent, and impartial tribunal established by law. The press and the public may be excluded from all or part of trial for reasons of morals, public order, or national security in a democratic society, or where the interests of the private lives of the parties so requires. And everyone charged with an offense shall be presumed innocent until proven guilty, and in the determination of criminal charge against him, everyone shall be entitled to following minimum guarantees and full equality. Okay, these are very many rights. Most constitutions in the world have this section when they are talking about the Bill of Rights and the equality before the law. There are some constitutions, they just took this section. They did not even waste time. And it's a very good place. Why I paused was because there is an understanding, and I think I want to confirm it without going there. Okay, Kenya is celebrating Independence Day, so that's why you're seeing Google is loving Kenya. And I'm going to the French law. French civil law versus British common law. So I had to do this because of that article. Let's go to a blog that makes sense. Yeah, so there's the list of national legal systems. Maybe let's go and hit that on Wikipedia. So these are the countries that have the common law system. Let's hit the flag, the map. And these are the legal systems of the world. So there is civil law, there's common law, there is customary law, there is Muslim Sharia law or fiqh, and then the subcategories Nordic, German, Chilean, and all of these. So when you look, let's come to the map here, and you have America is in a common law, then South America is the civil law, and then Muslim law is covering most of North Africa. No, I don't know why they have that funny green. I think I wish I could make them. There must be a place where they've told us that green means something. Okay, that green is part of the civil law and is in the middle of the civil law and Muslim fiqh law. Then you have, the map is really annoying because there are some countries, like I want to see these African countries that are orange. And look at civil law. My goodness, the whole of Europe is so civil law. And Britain and America are mostly civil law country. I mean, common law countries. Australia is also a common law country. Let's see China. China is in the middle of civil law. Okay, the map is not so lovely. I think we'll go back to the website. So sorry about that. Let's go back to Kenya, as they are French civil law. The contemporary legal systems of the world are based on 4 basic systems: civil law, common law, statutory law, and religious law, or a combination of these. However, the legal system of each country is shaped by its unique history, and it so incorporates individual variations. The science that studies law at the level of legal systems is called comparative law. Both civil, also known as Roman law, and common law systems can be considered the most widespread in the world. Civil law because it's the most widespread by landmass, and common law because it is employed by the greatest number of people. Yeah, and I think the UDHR has employed common law, and that's why I think what happened is because UN as an organization was set up in America, and America, as we've seen, is a common law country, and so most of the drafters of the UDHR included even Roosevelt's wife. She was the wife of the president, and she was the wife of the president, and she must have done what, being an American, she influenced the writing of the what do you call it, the UDHR. And so being an American, she was a common law citizen, and her understanding of law was common law. That's how I'm going to put it. Of course, we'll need to look at the drafters, but there's something about civil law that you should need to understand. Civil law is, of course, it comes from Rome, and it is interpreted rather than developed or made by judges, and only legal enactments rather than legal precedents, as in common law, are considered legally binding. So in civil law countries, the legislations are what make judgment, but in common law countries, the decisions of the court are what are legally binding. So the parliament is powerful in a civil law country, but in a common law country, the judiciary is powerful. Now, there is a French civil law and all of these, and then Chinese law is a mix of civil law and socialist law, and then you have Scandinavian civil law, then you have German civil law that is practiced in Germany, Austria, Russia, Switzerland, Estonia, Latvia, Bosnia and Herzegovina, Croatia, Kosovo, Macedonia, Montenegro, Slovenia, Serbia, Greece, Portugal, and its former colonies, Turkey, and East Asian countries, including Japan, Korea, and Taiwan. That's very interesting that German civil law is actually widespread in Asian countries. And of course, we've seen the Chinese. Then you find Napoleon moved. Then you have Swiss law. Look at the countries. Angola is Portuguese civil law. Argentina. I wish this page was arranged properly. They should have written a page showing us the civil law countries and the common law countries. So look at how many countries are so civil law. Okay, this is really maybe not a very nice article. It's not so clear. I wanted to look at the differences between civil law and the common law. Yeah, look at these countries. Let's see. Yeah, they haven't mentioned all countries. Oh, okay. So sorry. So sorry. Okay, they did what I wanted. Thank you. I was wondering. Okay, so all of these are civil law countries. So you can run through very fast, and then we go to the common law countries. So these are the civil law countries of the world, and I wish they were numbering. Albania, Angola, Bosnia, Brazil is also a civil law country. China, DRC, Cote d'Ivoire. Most French colonies are civil law countries. Ethiopia is a civil law country. Greece, very, very good. Of course, this is not our focus, so we won't spend a lot of time on it. Oh, Rwanda is also a civil law. Yes, because the Belgians ruled, and then the English came to kind of be friends with Rwanda. And then these are the common law countries. They are mostly British colonies. That's why America is a common law country. It belongs to Britain. It was colonized by Britain, and it is common in Louisiana. Very interesting. It's not part of Louisiana because Louisiana was a French colony, and Quebec is also a French province in Canada. So the French are very, very protective of their legal system. They know the meaning. And so I wanted us to let's look at the differences in the countries, how they, okay, that's the beauty of Pakistan. It has some provision of Islamic law, but it's a common law country. That's good for Pakistan. Because have you noticed there are very few Muslim countries. Of course, Bangladesh is there. And yes, there is America. And Louisiana is the only state that doesn't use common law. Then you have religious law. That's Afghanistan, Egypt, Iran. You see all of these Muslim countries. Nigeria, common law is in the south, and Sharia law is in the north, and Saudi Arabia. So basically, the religious law countries are Islamic countries. All right. Then pluralistic systems. The Vatican City uses both Roman, Italian, and Catholic canon law, and Botswana uses civil and common law. Cameroon, Cyprus, Guyana, Jersey, Lesotho, Louisiana, Malta. Yes. Mauritius.
If your phone is controlling the TV.
No.
It's not.
Yes. Sorry for that. That is a nephew that decided to pass by, and they do not understand when you're doing work. So we continue with our work. Quebec, we have talked about it. It's a mixture of civil and common law. South Africa is also a mixture of Roman, Dutch civil law and English common law. And Swaziland and also Zimbabwe is based on South African law and apply the law of the Cape Colony to Southern Rhodesia, now Zimbabwe. Now civil law and Sharia law, that's Afghanistan, Algeria, most of the Arab countries. Common law and Sharia law, I like this. These ones mix civil law and Sharia law. So these are guys who decided to go with the French, and with France and Spain. Then the common law and Sharia law, these are the countries that decided to go with Britain or were colonized by Britain. And then you have hybrid law. This is India. You see why India it's a very pluralistic country, and it's a mixture of civil, common law, and customary or religious law. So they have separate personal law codes applying to Muslims, Christians, and Hindus. And then you have Indonesia, based on civil law of Netherlands, and Adat, cultural law of Indonesia. All right, good. Now I wanted us to get There's something I was reading. Civil law versus common law. I think it's better to put it that way. Though I will go back to that and do my research. Okay, let's trust these guys. Sometimes there are some websites you fear because they don't look okay. This is the roles of the lawyer, their differences, and then no. That's what I didn't like. I was smelling a rat. We don't want a very civil law versus common law. We don't want a very heavy article because we are not focusing. This is not what we wanted to focus on. Yes, this is what I like. Let's come to images. Which is the longest? I think this is the best. Let's see how good it is. Yeah, this is better. So, in common law systems, the legal system nimeacha Okay, so sorry about the interruptions that are happening. That's part of life. So, common law systems, the continuity of the legal system is evolutionary, but in the civil law systems, it's revolutionary. And the major source of law in common law systems is custom and practice, and in civil law systems, it is legislative statutes. When it comes to relying on precedent, that is judgment that was made in the past, the common law systems, they rely on them very strongly, and the civil law systems do not really pay attention to precedent, that is judgment made in the past. And judicial role in lawmaking, judges are very active and creative, but in the civil system, they are passive and technical. And legal scholarship is secondary and peripheral, but in civil systems, it is extensive and influential. A judicial review of statutes and executive actions is allowed in common law systems. In civil law systems, it's not allowed. The major decision stage in the common law system is a trial, and the major decision stage is investigation and exam. This is what I was looking for, because it's where the presumption of innocence is based. And then in the trial format of the common law system, it's accusatorial or confrontational, but in the civil law systems, it is inquisitorial and collaborative, meaning they inquire. They don't accuse you. You see, the common law is for accusing, civil law system is for inquiring. And that's why when the Catholic Church was questioning the Protestants, because Protestants they were religious criminals, they were heretics, and heresies are crime in canon law. So because of that, they held an inquisition because the Roman Catholic Church borrowed the civil law system from the Roman that was not Christian. So they adopted the civil law from the Roman Empire and they used it against Protestants and they did it through Inquisition. It was called the Inquisition. And when you go for Inquisition, they call you. There's a panel of judges and then you're seated there, they inquire and they ask you questions. And remember, investigation and examination. So the time of Inquisition, what is happening at that time? They're investigating and examining you. And then they make the judgment there. But in common law system, you don't go before 4 judges, 5 judges. You go before maybe even 1 judge or 3 judges, depending on the gravity of the case. And then trial begins. And then one side, the prosecution, comes to accuse you of committing the crime. They confront you. Then the use of argument and debate is extensive and fundamental. That's in the common law system. So if you're very good in arguing in the common law system, you will win. But in the civil law system, it is modest and restricted because their issue is not how you argue. It is what the evidence that is available. And the style of legal reasoning is inductive. And the style of legal reasoning in the civil law system is deductive, meaning they look at the story, then they deduce. To deduce is to draw from something that already exists. But to induce is to introduce. It is reasoning. You reason from within. Induction. Reasoning from within. But deduction is reasoning from without. You see and then you reason. But inducing, you don't see, then you reason. You reason, then you see. What you see confirms what you reasoned in your head. Then trial emphasis, procedural correctness, but as you see, what I just told you, factual certainty in civil law systems. So the facts must be firm. If there are no facts, there is no case in a civil law system. But in the common law system, it is the procedure that matters. Evidentiary rules, formal and restrictive, and in the French system or the civil system, none. All evidence is considered. So, and the danger of the civil system, evidence can be fake. You see. So that's the problem. Fake evidence can come and implicate someone. Okay. And the functions of lawyers, debate and oppose. And the function of lawyers in civil system is advise and inform. The judge's role during trial is relieve and referee and umpire. And in the civil law system, he's a director and examiner. Yes, the judge that's why he has to be very technical. Citizen trial participation, juries, and in the civil system, it's members of judicial panels. Appellate review focus is mostly procedural. Yeah, so when you appeal, the judges in the appellate court do not go through the case again. They look at the procedure, at how the procedure of how judgment was arrived at in the lower court. But in the civil system, it's not only procedural, but it's also substantive. So they repeat the case to look at the substance of the judgment and the case. And in the unity of court structure is unified court structure and diffused court structure for the civil system. All right. That is, I wanted to look at that. Okay, so let's finish. I'm so sorry we had to do this, and I'll show you why. It's Kenya Independence Day. There you are. Google is telling us what is happening in Kenya, where we are. Civil versus common law. I just want to finish to let's just get to the point. I wanted to look at presumption of innocence. Yeah. Okay. Yes, this is what I wanted. Thank you. Okay, the civil law is a legal system. Civil law is the legal system used in most countries around the world today. You see? And it's from the Roman Empire. So, I'm looking for the statement of innocence. Innocence. So it's a very long this article. Of course, I've. It's just that the reason why I had to do this, I saw something in the UDHR or the explanation of the UDHR, and I really wanted to bring it out clearly. And these are civil cases, so I should be looking. Yes, this is. Let's focus here. Let's focus here. Okay, it has not really done it the way I wanted it. It's not really explained it clearly. But what I wanted to show you is the fact that in civil law, there's something very strange that happens that makes people not really like civil law. Is that the criminal presumption of innocence does not really exist in civil law system. Reason being, in civil law, the person is considered guilty and has to be proven to be innocent. You see, that's the problem. But in common law, it is different. Common law is what do you call it? They say in common law, it is not so. So what I was trying to bring out is that the UDHR is actually a common law. It's not even the UDHR. Yeah, okay. Wikipedia has tried to put it properly. Yeah, it has put it well. Under the Justinian codes and English common law, the accused is presumed innocent in criminal proceedings, and in civil proceedings, like, okay, yeah, that is they're talking about let me take the risk. This is what I was looking for. You see, in many states, presumptions of innocence is a legal right of the accused in a criminal trial, and it is an international human right under UN UDHR Article 11. So we have already gone to Article 11, but we'll talk about it deeply when we get there. But I wanted to check the civil law system, and that's what I really wanted to see, the presumption of innocence in the civil law system. Presumption of innocence in a civil legal system. Oops. It's supposed to be civil law legal system. Yeah, so the presumption of innocence in the French and Anglo-American legal traditions, but that's a GSTOR article, so I don't want to go there because I know those articles you have to be part of you have to subscribe, and that is going to take a lot of time. Okay, this is also an French. Let's put French system. That's the easiest way to get the answer. Yeah, that's the article, but we cannot go there. This one is saying, I would rather be accused in France than in Australia. Yeah, meaning I would rather be in a civil law system. So many people have choices to be accused in different countries. French law presumes accused innocent. Okay. This is interesting. Let's read this. Good. French law assumes accused innocent. Now, the French Declaration says everyone is being presumed innocent until found guilty. The French Constitutional Court has ruled that much of the Declaration, including the presumption, has constitutional force. The presumption has been the basis for legislation and judicial decision as recently as 1981. Of course, different systems often define and implement similar terms in different ways, but for instance, the people that should not be arrested upon mere police command, it's clear that the French presumption is more protective. So French criminal procedures usually start without an arrest, which the French consider a rather extreme and prejudicial event. Yeah, I mean, it's a bit prejudicial that you don't arrest somebody, but you have accused him of a crime. On the other hand, the right to remain silent, for instance, is arguably not quite secure as in France as here. So, what is very important is that the French actually presume you innocent, and that's good. You know, in the past, there was a view that the French or the civil law system and presumption of innocence was not really valued. Good. All right. Because this is burden of proof. Because look at this guy, he's written, lack of a presumption of innocence in the French legal system has long set it apart. So they don't presume you innocent, and that's what I'm trying to look for. Yeah, the consequences of the lack of definition of the presumption of innocence in Finnish law. So even in Finland, they have not defined that part of the law. Okay, let's come to Black's law. Then we end there. I think that one has saved me. In the modern Western world, it's one of the major legal systems. The other is a common law. Taken from Roman law, it is used in continental Europe. As we saw in the map, Europe is mostly civil law. Latin America, Scotland, state of Louisiana, and Quebec province. In this system, the law is highly structured and rigid code of rules observed to the letter. An expert judge decides cases without the help of jury and without any reference to precedent. In this system, every defendant in a criminal trial, and this, when you don't do precedent, it means the common law, the civil law is not a very historic system. They don't value the history of a case. And like the common law, they value history. In this system, every defendant in a criminal trial is presumed guilty until proven innocent. Under common law practice in most English-speaking countries, a person is presumed innocent until proven guilty. This is what I was looking for. As private law that contrasts to administrative law, criminal, ecclesiastical, and military law, and deals with individual relationships among individuals. So this is from the Law Dictionary, featuring Black Laws Dictionary, free online legal dictionary, 2nd edition. But I am not going to really handle this one. I'm a bit skeptical because Black Law has many editions, so I don't know what this one is trying to do. But let's end our research with guilty before proven innocent. Then that's how we'll finish it. Let's just go to the bone of the matter. Okay, this is a good one. Which countries treat suspects as guilty until proven innocent? There are disputed amounts regarding the number of nations on the planet, but most widely the figure is 196. I wish this guy could list them. Yes, but you see very many countries do that. And I think it's because the civil law system is very investigatorial. So because of that, when they do the investigation, they have evidence. So they come and tell you, you know what, we already know what has happened. So prove your innocence. But in the common law system, they let you go through a trial so that you prove your you are innocent, so you prove your innocence in the common law system. But in the civil law system, it is not so, because they already have evidence, so they call you guilty. But it's your job to say, I'm not guilty, and this is what I mean, why I'm not guilty. So you produce the evidence. So it's a bit understanding. I prefer the common law system. Why I've done this is because when I read the equality before the law, it was very clear about the rights, the presumption of innocence. That's what we're seeing. I see this whole thing. It's all about innocence and all about fair trial. So we won't read much about it. And it's also found in the Convention on Children's Rights, and it's also found in the International Protector of Rights of Migrant Workers, and basically an African Charter of Human Rights. So you see, even in African Charter, the right to be presumed innocent until proved guilty by a competent court. So what I was trying to look for is you should not be presumed guilty and then until you're proved to be innocent, because it's a bit very negative, and I think this is what happens in very many Sharia systems, because most of them that follow civil law. That's why it's very easy to punish somebody in a Sharia system, because when you are arrested, it is presumed you have actually committed the crime. And in a Sharia system, you are not necessarily innocent until proven guilty. You are guilty until proven innocent. So that's why we were doing that research, the difference between civil law and common law, the two main systems in the world. Good. Now we are done with Article 7, and we want to go to Article 8, and then we will be back.